And of course, you are going to tell us about yourself. And then, or before that, Sophie, why don't I talk about what we are doing? The symposium, what it's about, although it's, I mean, definitely someone who's watching this knows about it, but just the thought behind it. I mean, the point is that mediation legislation for me has been a discussion which I always felt was important, because that can change things. So this is what we're doing: mediation legislation, how, what, when, where, which, who, why of it. And idea being, let's keep an open mind. Let's not be bound by anything that has happened, but be critical about it if has to, appreciate it if we have to, but finally look at it from the promotion development of mediation. Then of course your thoughts after that. So now we have 50 plus speakers from 30 plus countries, and hope, let's see, maybe I'll get some more people that have to decide whether I have to extend the symposium or not. So Sophie, that's about it. No, it's not about it. No, it's not. It's not. I will because I want to finish everything off before you start, so that I don't interrupt you. The There is this website which you haven't gone to, which is called mediatorvikram.com, where you find information about the events and things that I do. So please, whenever you have to find out, please go here. Of course, all the social media links are here. You can get in touch with me. And the World Mediation Circle, which we have to look at from Georgia's perspective also. So a lot of information there. I won't get into that. Sophie, I'm done. It's all yours. Mediation legislation about Sophie. Anywhere you take it, I'll come in when you want me to come in. So please.
Yeah, excellent. Thank you so much. Thank you very much for the invite. And yes, do please come in whenever you have a question, and I'm happy to have a discussion on any point. So, and I wanted to comment as well that this series is also very interesting in the context of. I've listened to several live streams that the previous days, and it's interesting to discover many similarities, but also some differences between the countries. And I think a lot of learning can take place from each other's experiences. So thank you for the invite. I understand a little bit about myself. So I actually didn't my career didn't in dispute resolution didn't start with mediation. I come with arbitration background, so I was a very much arbitration person. I taught arbitration. I still am very arbitration person. But at some point, and that was in 2011, when the US aid program, rule of law program, started in Georgia. And that's when the USAID and the Georgian judiciary, they initiated and they decided to introduce mediation in the justice system as part of the access to justice purpose, and to increase the access to justice. So that's when actually I got introduced to mediation, because I was leading the USAID ADR programming. And when I discovered, I actually always tell this story, I actually remember the moment when I discovered the idea, the crux, what you call, I think, or Ken Clark calls the magic of mediation. And I actually thought, oh my God, how come world is not aware of it? How come people are not using it? And that was the first time actually for me to come across mediation in 2011. So it was from that time when we started to design the pilot program on mediation, when we introduced the very first provisions in the civil code of Georgia, and that was only related to court-annexed mediation. So at that time, the pilot was only in the context of mediations cases referred to by judges to mediation. A little bit later, I myself became a mediator, and I had my first mediations actually in the US. I went through the Harvard mediation program, and I mediated in the small claims courts of the Boston area. So that's when I had put my hands on mediation. And then I came back to Georgia, and I then started to become a mediator within the court annexed program. That was until the Georgia adopted the law on mediation, which was in 2019, when we adopted the law on mediation. It was the cycle of development of mediation in Georgia was such that, as I said, first we started to practice it in the pilot mode from 2011 to 2019, basically 7-8 years. And so there was only pilot regime and kind of testing, learning, and it was based on that experience, which showed good settlement rates, good satisfaction with the process, and so the time was ripe to scale it up, let's say. And also part of the whole policy consideration was the Georgia's association agreement with the EU and Georgia's drive to become part of the EU, and so to comply with the EU directives and legislation. So that was also what contributed to Georgia adopting a law on mediation, which happened in 2019. The law is the law. It's a good law in principle. I think it has all the very important components to foster practice of mediation. And by those key components, I mean, for example, the law provides for enforceability of the agreement to mediate. So if you have an agreement to mediate, the courts would dismiss the case and would actually tell the parties first to go and try mediation. So that's one aspect. Another aspect is that it does provide for confidentiality of the proceedings. There's few exceptions, but it has a very good framework for to foster the confidentiality of the process and to make parties feel safe about the process. It provides for, it doesn't limit the opportunity to seek interim measures. That's often something that very often lawyers ask. If they often commence litigation or they approach courts because they want to make sure that there is a security measure imposed or some interim measure carried out. So the law does not restrict that. So it's possible to seek interim measures and in parallel have the mediation proceedings. And the law ensures enforceability of the settlement agreements. So settlement agreements reached in the process of mediation, they then can become enforceable, can go back to the judge, and judge would approve them as a matter of judgment, and then they will be enforced. It will become an enforceable document. So in that sense, the law provides for those features and characteristics which often are important for parties, and particularly for their lawyers, to try mediation and to opt for this process. Another thing that the law regulates, and at the stage of negotiation on the law drafting process, in the course of the drafting process of the law, there was a divergence of approach, opinions about this, whether the law should also set up a regulatory body of mediators, or should it be freestanding model as it is in many countries, or should it be regulated? So at the end, the legislator opted for regulated model, but in the sense that the law has established a legal entity of public law, which is the Mediators Association of Georgia. So Mediators Association of Georgia is now the governing body of mediators. In order to be a mediator, one has to become member of the Mediators Association and has to be listed as a mediator with the Mediators Association. The Mediators Association itself is not a service provider. It's only a regulatory professional body. So it has set the standards for accrediting of mediators. It has set the standards for training providers, mediation training providers. It has adopted the code of conduct for mediators, and it has a an ethics commission. So if there is and there has not yet been any practice or any case with the ethics commission yet, which is good. But there is a body within the Mediators Association which would address the complaints related to mediators' ethical challenges, if there are any. And the Mediators Association is also in charge of the professional development of mediators. So it has developed and is working on some professional development courses, experience sharing meetings of the mediators. And another function for the Mediators Association is also that it collects annually. It has annual meeting, and it collects information on an annual basis and provides a report on the development of particularly court-annexed mediation in Georgia. So what the law has provided is that if before the law there was only and mostly court-annexed mediation and only in the pilot courts, after the adoption of the law applies to both court-annexed and out-of-court, the so-called private mediations. So those principles which I spoke about, which is confidentiality, traceability, etc., it equally applies to private mediations. Now, so we have this private mediation standing on the one hand, and then we have court-annexed mediation. Now, it probably is not a surprise that private mediation has not yet the take-up that we would want it to have. And most of the caseload comes from the judges, from the courts, referral of the cases from the courts. Currently, if I'm not mistaken, there are about 13 courts that have court-annexed mediation centers, and it is supposed to expand, and all the first instance courts of Georgia are supposed to have mediation centers available, and mediation is a process available for the parties. So with the court model, there are two ways to refer disputes to mediation, because with private mediation it's clear. In private mediation, parties go to mediation, at their own will, even before they commence, usually even before they commence any litigation or arbitration proceedings. Now, in the court-annexed model, there are two ways to refer cases to mediation. One is obviously when the judge explains to the parties what mediation is and the parties agree. So it's upon their agreement when they go to mediation. Now, another model is the mandatory referral, and that only is applicable to certain category of disputes. So, for example, in labor disputes, in family disputes, in neighborhood disputes, in inheritance matters, in small claims, financial disputes, intellectual property disputes. So, a list of categories of disputes. But the way the mandatory part operates in Georgia is a little bit different from the way it operates in many other countries, which means that, so it's not that all cases, all workplace disputes go to mediation, or all the neighborhood disputes. It's only those where a judge considers that this case has to go to mediation. So basically, the judges screen cases, they look at their caseload, they look at their files, and then they decide that certain disputes, in this particular case, the parties should give a try to mediation. And that's when they direct the parties to mediation, irrespective of whether they want or not. I know you're not very fond of mandatory mediation. I've heard you find it oxymoron to have mandatory and mediation standing together. I think I understand where you're coming from. I think the words themselves, mandatory is a very strong word, and mediation itself is all about consent of the parties and all about, their will, and in its nature is a process which is about the parties and driven by the parties. So it does sound counterintuitive, the two words. I think once we get into the details of to which part of this mandatory language applies, I personally have become a very supporter of the mandatory mediation. in the sense that we mean mandatory referral of parties to mediation so that they go and at least try. So what they have to do is go and give it a try. And so I, as a mediator, and I also mediate the court referred cases. So, for example, when the court has sent to me a case, which was a mandatory referral, it was a workplace dispute, and not just one, actually, several. The first thing that I tell to the parties in my opening statement is that it's a voluntary process. So the first thing that I tell the parties who come to me with a mandatory referral by the judge's order, the first thing I tell them that it's a voluntary process. So at any point they feel that this process is not corresponding to their interests, to their expectations, they don't feel comfortable, this is the process where they can raise that issue, we can discuss, and they can leave. So it's a voluntary process, everyone, for the parties, for me as well. And I've never had a case, and I've been there since I think with the court annex program in Georgia since 2017, and that makes 5 years now, almost 6. I've never had a case where parties left the process. So and actually, I read somewhere on LinkedIn, you're aware that now there's a big discussion about expanding the scope of mandatory mediation in the UK. So the mandatory mediation is a big issue now. And so I was following on LinkedIn, and there was a very good comment, which actually I liked very much. There was a comment about comparing a mandatory mediation and some, opposers of mandatory mediation saying, it's, as you said, it's oxymoron. You cannot make, and there was this analogy saying you cannot make a horse drink the water. You cannot force a horse drink the water. And then the supporters of the mandatory mediation saying, well, if you bring the horse to the river, it usually does drink it. So I like this analogy in the context of, especially in countries like my country, where people do not know what mediation is, because for many years, at least in this recent history of Georgia, the only way for them that I've heard that it's possible to resolve disputes is litigation. So when parties don't know what mediation is, they usually don't try what they don't know. They don't like what they don't know. They're hesitant to try what they don't know, and it will take a lot of many years to ensure that everybody has a good feeling and understanding at the comfort level to appreciate what mediation is. And so until we wait, I personally find it justified to bring that horse to the water, and then give the choice to them whether they want to drink it or not. And I think the practice in Georgia and in some other countries that have followed and have worked in some other countries as well, I think it, in principle, it works. Obviously, there needs to be things in place. For example, their access to justice issues. Whether in Georgia, for example, that's an important part of the court annex program, is that all mandatory referrals, they're free for the parties. So the government funds for the parties the process. So they're not really losing anything, not even time.
I can't wait any longer. I have to come in now. I can't.
Yes, please.
This is because you just said something which is the most important part in the whole thing. It is free for the parties. I am saying parties is not the word I use. I say participants, of course, that's a different thing, but free. The fact that because you cannot tell them to pay and not pay the mediator also, because in your case, there are certain number of mediations you have to do free under your legislation itself. In the court system, you have to do them free. Imagine which other profession can you force anyone to do this, if it's a profession or anything that people otherwise are making a livelihood of. I work outside the court system. What am I competing with? Sophie doing it for free in the courts. Why should you do it to me? Why? I don't even understand. Okay, you want to do mandatory, push everyone into mediation, send them off. But the mediator is going to be paid on market rates. Let them do that. They will be, it'll be challenged, because they are going to say the courts are there, we have access to the courts, why should you send us to another process? So for that, let's keep it free. Why are you doing this to mediation? Why are you doing this to mediators? That's the starting point. But how efficient are your courts? What is the efficiency level of your courts? How many pending matters? How much time does it take?
Quite loaded. I mean, I don't know. It's all comparative, obviously, but I mean, if you count all three levels, you need at least 3-4 years to get the final decision. But it's yeah, the caseload is a problem. So that was actually the triggering point for introducing
Exactly.
mediation as well.
This is a
Yeah.
situation everywhere. I am saying, court system, you become the most efficient system in the world. People do not want to go for mediation. I'm happy. At least they're getting justice. And access to justice, giving them access to mediation is access to justice. Their judiciary will keep fooling everyone because they're overloaded and they have nowhere to look. Okay, let's do this. This is access to justice. Why? Me sitting with someone in my house and settling a matter, I've suddenly got access to justice. I mean, it's crazy, absurd, and more absurd, and even more absurd as it goes along, because the starting point is absurd. The fact is, in your country or every country, create that culture that people feel that yes, they should want to resolve things amicably and through mediation or otherwise. I mean, I'm not saying you must go for mediation. Try and do it yourselves. You don't need a third person. Do it yourself. If you can't, you get to a third person. But that, you haven't started there. You started from the inefficient judiciary pushing its agenda onto the people. Why should I, as a taxpayer, be funding someone else's dispute? Don't fight. Yeah, you had to pay this guy, pay him. I'm not concerned why you didn't pay the person, but I'm funding that dispute because the judiciary is inefficient. They don't want people to pay because otherwise they'll challenge the legislation. So taxpayer should pay, mediator should get nothing, mediation should be linked with courts and free. I mean, what are you doing? It's not worked anywhere in the world for the last 50 years. Please give it up at some stage. And the interesting thing, you are 3.7 million people. UK is 67 million people. India is 1.4 billion people. Everywhere it has been attempted, private mediation has not developed. US 300 million people. It has in 50 years, it hasn't developed. Private mediation is not developing. Your court systems are still overloaded. You are not working at the efficiency of your court system, but at least to say that, oh, we have this process. Now look at it from another person's perspective, Sophie. There is a person who's lying in jail, innocent person, because people are put in jail when they're innocent also, and the conviction happens later. There are people, I don't know, I'm sure in Georgia also they're done. First of all, you've taken someone's freedom away. You've got the most inefficient institution not being able to decide that matter. It should be decided in 1 hour. How can you take someone's rights away, and you send the person to a cage, which is like for animals? And the judiciary has the right to do it, and the whole colonization mindset that we can send someone there. Now this person is lying in jail. What is this judiciary doing? Sitting with someone who has to pay someone maybe $100,000, let's just give an example, and saying, oh, I think this is a fit case for mediation. That 5, 10, 15, 20 minutes you wasted on that, well, this person was lying in jail. Why are you doing this to that person? You don't have time. You're inefficient. Get to your work. Either you settle this matter, I mean, decide it, or just let it go. But don't waste your time telling people about mediation and how they should settle the matter. One on the other end, the other person is languishing in jail because you are inefficient. I mean, just look at it from that perspective, that there's a time. Court has certain time, and they are, of course, not being able to utilize that time to finish off the backlog. So I just feel that even that time taken to explain to people that you should go for mediation is at the cost of someone lying in jail. I always look at it from that point of view. You push everyone, push all your caseload out, do whatever you have to. No, don't do it at the cost of mediators and mediation. It's a very serious matter. I mean, tell me, Sophie, because like I said, maybe at 3.7 million people, you look at it maybe a little differently. I don't see it any different, because whatever you said is the same situation in every place. So think of it from this perspective. We'll definitely go into that, because when it said, your legislation said the mediators will have to do it free, did the mediators not protest against it? Why don't they protest against it? Which are had the lawyers been told that if you have to practice in this court, this many matters you have to do for free? And the word used in your legislation is pro bono. First of all, someone who can afford that mediator's fee, is that pro bono? It's free, not pro bono. Pro bono is maybe some people who can't afford something like legal aid. I can't afford a lawyer, so you give me legal aid. Maybe considered pro bono. People who have millions of dollars, they're fighting against each other, but this is considered pro bono. Why should you? Why should it be done? Why don't the whole this? We'll talk about the, of course, this whole the association and all that, but the free part of it, no one challenges. Why should it be done? No, stop. I would say stop free mediations are totally okay. A little more too much I've said. Now it's Sophie also.
No. That's and I'm actually partly with you in the sense that, well, first of all, it's only, if I'm not mistaken, it's one, maximum two. I have to check with the regulation of the Mediators Association, which is pro bono for the mediator. Everything else is paid by the state to the, so it's not that mediators do it for free all the time. They do one mediation, maybe they have to do pro bono, and that's it. But that doesn't eliminate the problem. The problem is, and you'll be even more surprised, is that the problem is that even in those cases when it's not free, and in most cases, so when mediators get paid by the state budget for the mediations they do within the court annexed program, the pay is such minuscule that it's actually offensive.
Absolutely.
So, I'm not saying mediators are happy about that. We actually had very big contentions with the legislature, with the judiciary too, and we still do, and we're still working to make amendments to increase the fee for the court referred mediation, because apart from the fact that it's free, it's devaluing the profession.
Exactly.
It's improper, and I think what you're saying, that I don't know a person in Georgia who would do mediation as a matter of not even full time, but it would do it for economic considerations or have any meaningful economic consideration by doing mediations. Everybody does it. Either part of us do it because we're enthusiasts and because we want to, but that's not sustainable. That's not proper. That's devaluing the profession, and that's actually not even considering it as a profession. So it's something, oh, your mediation, have fun with it, kind of attitude, even by lawyers. Kind of you see very often, diminishing the importance of the work that mediators do.
Exactly. And the
So
mediators
in no
themselves.
way I'm saying that's good or that's proper or that's a good model. I'm not saying that.
No, I've heard from a very senior mediator, and he's a lawyer who's also, when he says he walks into a court into one of those, these multi-door courthouses, and when he goes in as a mediator, the way he's looked at by people who are in that mediation, I mean, they don't, the concept is, what does he get? He doesn't even get as much as my clerk gets. That's, I mean, we're living in a materialistic society. Everything is valued in terms of money. And on the other end, what you're saying is that these people, okay, they're there, but they're not worth anything. When you start with there, how are you going to create the culture? How are you going to stop things from coming into court? We have to look at a long term. This short term policy of the inefficient judiciary, the most inefficient institution in the country, every country, and they're getting away with it. That's the best part. No one can question that aspect of it, because I call it the colonizer's mindset, that judiciary no one questions. They're getting away with it. But all I'm saying is this: all the mediators in the world who are doing it for free in courts, just stop doing it. Just stop doing it. Why we not? I mean, if it is, of course, it's a negotiable thing with whatever fees you want to negotiate with people. Everyone's need is different. Someone might negotiate a lower fee, someone might not. But that's up to them. That's in individual situations. Because what I'm saying is that a litigating lawyer is in the same courtroom allowed to charge what the person wants. Is that person doing a better service? I think we are saying that no, the mediators provide a very good service. They settle something which is permanent, and this is something where everyone is supposed to go back happy and everything. But no, these guys are not good guys. litigating lawyers should get what they want. So I'm just saying that let's start. Of course, now let's talk about the association part of it. There is a certain register which requires a certain kind of training and certification. So a little bit about that. What is that training? What is that certification?
Yes. So to become member of the association, there are 3 stages that a person has to go through. The first stage is training, and the requirements for the training are set by the association. It has to be minimum, I have to check, it's about 60 hours of training at minimum. And so there are also requirements for the training provider. So it has to be interactive, it has to have role plays, blah, blah. So some general considerations of what they, it cannot be theoretical training or, so the first stage is training. So once the person goes through the training and has a certificate from an accredited training provider, or if it's a foreign training provider, then the Mediators Association would recognize, would need to, one would have to apply, and the Mediators Association would approve that. So once this training is done and the certificate is in place, then the person will undergo a mock mediation within the association. So over the course of 2 days, a candidate, we call a person a candidate, comes to the Mediators Association, and there are certified assessors who sit as to shadow the mediations, and then there are parties, usually those are interns of the Mediators Association. And so there's a mock mediation which the candidate over the course of 1 hour has to mediate a mock case. And so that kind of examination is done over two days. So a candidate has 2 days to demonstrate in 2 different sessions with 2 different assessors his or her mediation skills. So once this assessment, and so there are assessment criteria, and the assessors are trained for, to have more or less uniform standards of assessing the candidates. Once the assessment is done, then the person has to apply to the Mediators Association to become a member and has to shadow 1 real mediation. So before the person takes up a case on his or her own as a mediator, has to shadow a real mediation and write a short observation about the real mediation, have a talk with the mediator. So that's more kind of a transition stage where the person gets to see the real room, the real parties, the real process before he or she takes up, stands in the shoes of the mediator. So this is the process of becoming a member of the association and becoming a mediator.
And this is anyone can go for this training, and anyone. I mean, so there's no such qualification for who can go.
No, it's not limited to professions. We have obviously, as it is in many countries, majority happen to be lawyers, but we have psychologists, we have I believe a journalist, so we have non-lawyers as well as members of the association.
But what is your view on the whole concept of training and this certification process? One is, of course, who are the trainers and who are the assessors? How do you, is there a certain qualification, certification, training for them, or this is, or, I don't know, how does that work? Who are those people? Let's get to those people first. Who are the trainers and who are the assessors?
Yes, so I'll start a little bit with a little bit of history, how mediation training, because that was in 2011 when I worked with the USAID Rule of Law program, when we trained the very first pool of mediators in Georgia. And so we at that time, we collaborated with the Center for Effective Dispute Resolution, CEDR, from the UK. And so they, CEDR is a golden standard, so excellent training. So they got the best training, in my personal view, that we could have provided to the first generation of Georgian mediators. From then on, there were some other providers as well, and so there are obviously mediators trained by different training providers. As regards the trainers, because I think I'm getting now to the trainers. You asked who are the trainers, how have they been trained. So Georgia, again, it was usually the development of mediation in Georgia was supported. Georgia has been lucky in that sense, has been supported by several international organizations like USAID and EU and UNDP. So at a later stage, it was EU UNDP program which trained the trainers. And it was also done with SEED, so it was Center for Effective Dispute Resolution, who helped train the Georgian trainers. So the first pool of the Georgian trainers, who then became the trainers accredited by the Mediators Association, were trained by SEED, and then they trained the next generation of Georgian trainers. And so this is where we are. Obviously, of course, as the numbers will grow, the numbers of mediators will grow, the numbers of trainers and training providers will grow. There will always be, I would say, issues related to quality, and so we would need to be careful about that. I think that's a natural kind of tendency when you grow to keep control of the quality.
Because actually, how I looking at, of course, I don't know whether you had a look at the CEDAR audit that they had.
Yes, I have. Yes, I have. Yes.
Then you saw the numbers there, 17,000.
Impressive.
Impressive. Come on, 17,000 mediations in the whole year in the UK, in the England.
Well,
In the whole,
it's all comparative, so that's why for me.
17,000. I mean, can you imagine? That's like, I mean, in terms of number of these certified, accredited mediators in the UK, will be more than that. So what is happening is very gold. You said gold standard training and all that, very good. But the point is that person finally wants to do some work, but work is not happening. I'm saying there's a mismatch. There's something somewhere, Sophie, that
it's everywhere. I see it everywhere, and I think now again, I'm not an expert. From the numbers that I've seen, UK is even doing better than other countries. I mean, in terms of private mediation, because even the SEED report, the numbers that they show in terms of the value of the disputes, and the impact on the economy and the value of the disputes, it's still like this. And we're talking now about mostly private mediation. There are some schemes as well, obviously referral schemes, but still compared to, at least on the continental Europe, to other countries, the numbers are compared to the UK minuscule. So that's, for me, it's comparative. Comparatively, I think those numbers are still better than the numbers on the continental Europe.
But look, finally, look, what you have to compare with is how many are going into courts. That is what you compare with. The point
ratio.
Is that, it has to be compared with that. I mean, 17,000 mediations in the entire year is like, for me, just the fact that, okay, I'm good, we are growing or whatever, you can show statistics there. But in terms of the larger number of matters going into court, nothing has changed when all the trainings and accreditations available, those people available. So what I'm trying to say, that churning process is happening. Those people are coming out, those factories are running, those 40-hour factories are running, people churned out. But if it's not working out, what is the reason on the ground? If what we call private mediation, which I keep saying is the only kind of mediation that should be there, that is, to say this is private, I think we're just not, the whole concept of mediation itself has been looked at this, with this court annex thing, gone into that direction. It should just be private. Everything should be private. Is their dispute, they take it up. But from that mismatch, I'm just trying to say, Sophie, is that there is finally, there has to be a long-term strategy somewhere in relation to mediation. And where do we look at that long-term happening? Because what is long-term? In US court system, 50 years. In the UK, this aspect of training been there for many years. All that being there, if it's not being is not something that people will use, if it's not given to them for free, what do we have to work on? First of all, is this process of training, accreditation, is there a issue there? That whole concept of the assessment or the people who are training, is there a problem there? Is it the fact that people do not, there's no culture of mediation? colonization mindset that we have to go to courts? Is that the issue? Because finally, if we have to look at long term, we'll have to change it at the grassroots level. So where do you see where do you see the issues?
Okay. Well, I mean, I think there's no one issue. There are several issues. By the way, there is a very good research done by Anna Howard. It's called EU Cross-Border Commercial Mediation: Listening to Disputants, Changing the Framing the Changes. So she interviewed the users, and there are very interesting, insights from what the users think and how they approach mediation. So I think there's no one. It's and I'd be happy to also hear your views then. What's the issues and what can be done to change the frame, to change the reality. So I think there's several things. Obviously, awareness raising is a problem, and but more than the awareness raising, so what I've encountered, and that's also mentioned in Anna Howard's research, is that very often parties perceive mediation as a not just sign of weakness, but it's as if, well, if we go to mediation, it means that we haven't been able to deal with it ourselves. And so it speaks it's not necessarily a positive trigger that they have about themselves. And so I think there's that barrier of how they perceive mediation, what it means for them to try mediation, to go to seek the assistance of a mediator. I've had that in my practice as well. Just when, and even in private mediation, when the parties refer the case to mediation, I've heard from one party saying, well, they initiated the mediation. That means that they have a weak case, and so we are kind of here. So I've heard that in my practice as well. So it's still perceived as a sign of compromise, readiness to compromise, and weakness. And there could be several ways to overcome that. But I think one way to change that is to put a focus on mediation clauses in the contracts, meaning that if you and I have a contract and we have in the dispute resolution clause, the clause says that before we commence arbitration or before we go to litigation, we have to try mediation, then that saves the face for me and for you, and that saves this idea that I called mediator. I initiated mediation at my own will because I feel I have a lot to lose, or I feel insecure. No, because I can make a reference to an objective point, to a contract, and say, well, we have to try mediation because we have it in the dispute resolution clause. So, like in my view, that could be one way how to overcome this this barrier of initiating mediation without the fear of being perceived as insecure about or weak about your position. Lawyers are a big issue. I think you've many of your interviewees, many experts spoke about lawyers as well. One thing which was very distinct about Georgia was that when we trained the first pool of mediators in 2011, and I actually take credit for that, I will not be modest, is that we actually made sure that in the first pool of trainees, we had representatives of the Bar Association of the famous lawyers, let's say prominent lawyers. So we had, and I think it worked because many of they got what do you call it? They got beaten by the mediator bug. They liked mediation. They love mediation. They understand mediation. And so because we had this leading lawyers becoming mediators and really appreciating the magic and the value of mediation, then and today, the Georgian Bar Association's leadership is still, very much pro-mediation. Many lawyers who have been trained as mediators, they promote mediation, and so that I think has helped Georgia not to have that, at least at least a loud-spoken opposition. Obviously, we have like thousands of lawyers, and I'm not saying all of them love mediation. Obviously, they're still opposing. They're hesitant to refer their clients to mediation, um, uh, but it helps when you have prominent lawyers sincerely sharing their good experience about mediation and trying to promote mediation. So yeah, lawyers is an issue. Another thing I was actually also thinking about, because the countries, the governments also try to promote. So Georgia, for example, Georgia's government was, with respect to dispute resolution, arbitration, mediation, has been always supportive. So we adopted the law on mediation, we signed the Singapore Convention, we actually ratified the Singapore Convention. There are not many countries who did that to promote itself as favorable seats or favorable, countries for collaborative or out-of-court dispute resolution. Now, having said that, I would expect that government agencies themselves would use mediation. So I think that's another big triggering point, because when we're talking about promoting mediation, I understand your concern that it should not be court annexed. Like, people should go to mediation at their own will, and private mediations should strive. But how somebody has to know? They will not dream about mediation when they're sleeping, right? Somebody has to give them either information. Either lawyers have to refer, or judges have to refer, or institutions have to have either internal or external, like, mechanisms or grievance procedures which incorporates mediation. Like, at some point, somebody has to inform the parties and kind of be a trigger for them to try mediation. And I think public agencies can do a lot in that respect to promote the usage of mediation.
But look at the double standard there. That on one end, you were saying that the people should be forced into mediation, and Georgia, while ratifying the convention, has said it will not apply to those situations where they are a party. So can you imagine? We don't have faith in the process, but people should have faith in the process. We'll push you to the process. I think these are there are going to be such double standards because the whole foundation is so weak there. These are things which are going to keep coming up. But look, from my perspective, how do I look at it? I look at it as something which is that technical word, mediation. Let's keep it aside. Now in Georgia, let's look at, in your language, what is that word that people would connect to, which is a process where a third person assists you in resolving a dispute. So let's find that word. Let's find out with people, what do they connect that word with? Is it actually about someone assisting and not making a decision for you? Or is it someone who actually makes a decision? Because the arbitration, mediation, clarity should be there. So we have to first get to that point, that is this the right word we are using? Once we have that right word, then we ask people about those people in your communities, in your organizations, in business communities, wherever. Who are those people who have that mindset and who are actually maybe doing it? Let's get those people out. Now, no mock mediations required. These people have already done that. Their user experience is guaranteed. Now, what else do we want? Do we want now that a person who's giving a good user experience? No, this is not good enough. We want to give you some training which was put out by someone somewhere, and then only you will be a mediator. We have to get over that. No, this person is a mediator because people have chosen this person as a mediator. You don't need anything else. The only thing is that these people should be out there. This is where maybe governments can come in, because of course this should also not be a government thing. This should be private initiative. It's to bring these people out, and then to be able to actually coordinate mediations, which I created this World Mediation Circle, and I said we'll identify those with the mediator mindset, but we'll also identify the peacemakers. Who are the people who will actually reach out to people? Because reaching out to the other side is by itself a skill. And getting them together is a skill. It's not just mediation. Mediation only happen when people get together. Like you said, a lot of resistance there. So someone has to break that resistance. So those people have to be identified also. So first you identify those with the mediator mindset, then identify these people, then that right word to be put out there, so that to explain the process becomes much easier, because they connect to that word. Otherwise, the moment you use the word mediation, courts, lawyers, guess gets that connection will come in, because you're a small country. This is what's going to happen over time. Here we're still a large country. People might not have heard of someone who might have used it in the court system. In your case, that'll happen much faster. So that association has to be taken away. Then let's look at legislation. Let's look at legislation, which I'm going to ask you. In this kind of a scenario on development of mediation from this perspective, how would you look at legislation?
So a couple points. I myself kind of your point about whoever parties choose as a mediator means it's he or she is good enough as a mediator because parties have chosen. So I think that's a concept which applies just like that in arbitration. So arbitrators are not licensed in Georgia or
Exactly.
almost anywhere, right? So it's totally up to the parties, party autonomy. So the legislator comes from the view that parties know better for themselves whom they want as their decision maker. And if you compare, the role of the arbitrator is more in terms of significant in the context of the consequences. An arbitrator makes a decision, so it has like legal consequences for the parties, right? And that's not regulated. And then you have a mediator who facilitates the process. And then you have this whole framing of like a lot of scrutiny about who the mediator is. So as I said, there were discussions about it. It was not a straightforward matter to have the profession as it is today. Now, coming back to the issue of you said that the mediator should be the word should be something that creates a connection with the people of a particular country, and that actually reminds me to talk a little bit, if that's okay, about the historical part of mediation in Georgia, because in Georgia, actually, in centuries ago. And I'm talking about like medieval and even before. So we had mediators, and the word mediatori in Georgian, mediatori, which is mediator, has been part of Georgian legal culture for centuries. And particularly, it was actually in the mountainous parts of Georgia, even later in the 19th and 20th centuries. And even today, in Svaneti, which is a beautiful part in Georgia, there are these historical mediators who used to settle and still do disputes between families. And now the mediation mostly emerged as in that respect as something to help people survive, because there was a lot of still is actually not so much, but still a revenge and redemption through blood tradition in the mountainous parts of Georgia. And actually, what you spoke about, you said there should be somebody who goes to the other party and gets the other party in the process, right? So actually, in the historical sources, historical sources talk a lot about not just the mediator who mediates the disputes, but then there is a separate word. I could say maybe in English version would be, I don't know, facilitator, intermediary. So intermediary would be the best word in English to match that. So historical sources talk about intermediaries who would take sometimes months to go back and forth from one family to another, and just trying to get them used to the idea that they have to reconcile. So, and they had they were the most important role in this process, because once they would have the families agree, okay, like we can now try that process, then the mediators would come in, and they would then the mediation would take place. So I very much agree with you that we need this intermediaries or promoters or trusted people with authority and trust, who would give information to the parties and well, and create credibility for the process, and get the parties in the process, let's say. You know, traditional mediation was what in my view, was a hybrid between mediation and arbitration, because the mediators would actually often make decision as well. But I think the mediation part was there because it was not just about the decision, it was about reconciliation. So the part about reconciliation and kind of forgiving each other, understanding each other, building, well, maybe not rebuilding relationship, but at least not staying as rivalries anymore. That was there. So it was more of a hybrid. But so my point is that a mediator as a word is something that is not foreign for Georgian community, and is actually something that they would associate with trust and authority of a person. And actually we say that it's a very what does it say? A good profession. It's it's I don't know, good role to have as a mediator. So that it has a positive perception within the community.
What I'm trying to say is that these are things which we need to strengthen, and of course, distinguishing between the mediators and the arbitrators definitely needs to be done, and not connect. Like I said, don't connect with the wrong word, because that by itself is going to change everything. Because once you connect that, then it's going to be, this is another person who's going to take a decision for us. Why do we have to get this person? We'll just go to the court. So that is one thing which I know. But what I'm trying to say is that structure has been there, and this is why this series of symposia, that this one is the 8th one, was basically like this only. The first one 2 years back was mediation in our culture and traditions. The whole idea was to discuss these aspects, because if we have to connect people to the process, first of all, we have to be able to find out what that process, how it existed. So that's the first stage. Then it was, of course, then it moved to heart, soul, spirituality and mediation, because I'm saying there's lots more happening there, which of course, all this training and that you talk about, for me, it's very limited concept of the understanding of mediation itself. So that was the symposium. Then it was the colonization, decolonization and mediation. Hi, Rafael. Rafael, we're just wrapping up in we have 3 minutes. We have 3 minutes. So after that, you can say hi to Sophie. So basically, that part of how colonization affected things. So colonization, decolonization, mediation, then indigenous peoples and mediation, because that part of it is linked to the aspect of mediation, our culture and traditions. But okay, this is a little more specialized in that sense. Then we had on neutrality and mediation, because again, training 40 hours, you say mediator is neutral. Come off it, is it the situation? You can debate that for 40 hours whether a mediator. We had about 17 sessions. I'm saying I have about 17 hours of content on neutrality is lying on my channel. So I'm saying each of those things I've tried to put together. So that is why legislation, I feel, okay, this was something that I had to do, although for my focus now is on the World Mediation Circle. So please read about it, because I think what you're saying about the traditional concept, you'll see a lot of linkages there in the way I'm structuring that. And for me, that's the way forward. And legislation for me should not come in the way of creating that grassroots movement. So for me, I'm looking at it from that perspective, that we have to let it be a people's process. And if we really don't understand in terms of what all goes into the process, so you say, okay, I can train you to be a mediator. I think I don't think that's the correct thing to say, but people are saying that, and that's going on. The only people who make mediators are the people in dispute, and they can make anyone a mediator. And that the trust seems to be one word which, of course, goes on. But Sophie, we'll wrap it up here. Any last remarks? Anything that you want to put across?
Last remark is just I'm a strong believer that the earlier we start, the better it is. I train, I teach students, and I think that just because changing somebody's mindset, once we have been trained as lawyers for 4 years to be adversarial and to be competitive, then it's very difficult to change that. It's possible, but I think at a large scale, all law schools, business schools, they should have mediation, interest-based negotiation trainings. I've already experienced that some of my students whom I've trained 4 or 5 years ago, they've brought parties to mediation because they believe in the process. So I think early training, is key to promoting to the level that you want and that I want and everyone wants, so that mediation has a large scale take up and it comes naturally.
So basically, this World Mediation Circle and Georgia Mediation Circle, it's a good experiment with only what you have, 3 million people, 4 million people. So it's a good
Yeah.
experiment to
So
have.
three and a
Let's
half.
create that.
Don't cut the half.
I'm saying 4. I'm saying 4. Some of them were not counted, maybe. But let's. So we'll develop that. We'll go there and do it. So thank you very much, Sophie. And
Thank
of
you very
course,
much.
you can say hi to Rafael. He's doing excellent work in Mexico, which he's going to talk about. So I'll just stop this recording and